Assalamu alaikum, everyone. Thank you for taking time to attend our webinar. As the Brother Kabir said, that I've been an attorney for 27 years. I taught Islamic law for 17 years at Rutgers Law School. I'm a leading authority on the role of Sharia in American courts in the country. Uh, in my 27 years of practice, I primarily represented Muslim families. And from that expertise, I leveraged to launch Sharia Wiz. ShariaWiz.com is the leading and most trusted platform for estate planning that's Sharia compliant and prenuptial agreements that are Sharia compliant. We did it to make it accessible because in my private practice, it is quite expensive to hire lawyers, and we wanted to make it easier for everyone. Despite the fact that I am a lawyer, I'm not providing any legal advice tonight in my presentation. I'm giving you general legal information, not to be misconstrued as legal advice. If you have a complex case, you need to speak to a lawyer. You need to retain someone. So I am a lawyer, but I'm not anyone's lawyer that is attending. With that, we're going to go through a explanation of the Islamic law of inheritance. Then we're going to explain estate planning, will versus trust. And then I'm going to open it up for questions because as Brother Hamayun and I have experienced, we've been doing this for years, is most interest is in the questions. I want to provide you with a basic intro to provide a foundation for you to understand what's going on in estate planning and the role of the Sharia in providing our plan for preserving our wealth, fulfilling our faith, and protecting our family. So the Islamic law of inheritance is a mandatory intestacy inheritance system. What that means that if you live in Pakistan, if you live in Palestine, you live in Egypt, you live in Saudi Arabia, when you pass away, your estate is distributed according to Sharia that is codified in the laws of these Muslim countries. You don't have much leeway to distribute your estate because the Quran in Surah An-Nisa had created the fractional shares that each Muslim survivor will be entitled to from the estate. However, we are given up to 1/3 of that estate to give to charity and to other beneficiaries, and we'll talk about it further down. So this intestacy, it's an apportionment from God. So the Sharia divides your Islamic heirs and Islamic beneficiaries into three categories. The first category is Quranic heirs. Quranic heirs are what is set forth in Surah An-Nisa. And in Surah An-Nisa, it says if you're survived by a mother, she gets 1/6. By a father, he gets 1/6. If you're survived by a grandmother, she gets a certain amount if the mother is predeceased. All of these fractions and shares are in the Quran. It's either 1/2, 1/4, 1/8, 2/3, 1/3, 1/6. These are the fractions that are in the Quran. And look, 9 of the entitled obligatory heirs, Quranic heirs, are females. Give you kind of an insight that the prophetic message, the divine message of Islam had gender equity as the forefront of reconstituting pre-Islamic Arabia, and that women and their protection, their contributions, their engagement and involvement in the legacy of Islam is really key and core to the moral framework of the Quran. So these are the list of who receives an inheritance guaranteed in the Quran. Next category that the scholars created is those who are taken by tasib or residuary heirs. This means that after you pass away and you're survived by your mother and your father and your wife and your children, your mother is an obligatory heir. She takes her 1/6. Your father is an obligatory heir. He takes his 1/6. Your wife is an obligatory heir and takes 1/8. What's left is then divided, double the share for the female to the children, double the share for the son versus the daughter. So those children are taken as residuary heirs, not as obligatory heirs. So they're not Quranic heirs. And I just explained and gave you this example. If there are no children, then the siblings will take the balance remaining. If there are no siblings, then the nephews, and so forth. If you do not have any Ahl al-Fara'id and you have no residuary takers, then we go to the maternal side, and that is called Dhul Arham. And this, in my whole practice, I've never had a situation in my practice that implicated Dhul Arham, because even if you are a revert and you only have a spouse as Muslim or you don't have any heirs, it doesn't matter about the maternal line because they're not Muslim. So it would have to go to a list of whoever you wish and charities. So this is one of those circumstances that's rare. We are very strong extended families as Muslims, but in those rare circumstances, that's what is the third category in the Islamic law of inheritance. In addition to the pretty straightforward, here is the list of the fractions in the Quran. Here are the folks in the paternal line that will take by residuary. The scholars created some legal principles that will work in evaluating and determining who are the Islamic heirs and what are their shares. One of those is called the concept of rad. Rad literally means to add back. So when the total prescribed shares does not exhaust the entire estate, the balance left will be distributed according to either the doctrine of Rad or Ta'sib. So let's say that we had a circumstance where there's a father, there's a mother, and there's a surviving wife, but there are no children, but they're siblings. In this case, in many of these cases, the father may receive the balance because we only had 1/6, 1/6, and 1/8. There's money and property left. That will be returned to the folks that had already received a share proportionately. The Tasib I already explained to you. The next one would be Awal. And awal is when the estate actually the fractions exceed 100%. So when the fractions exceed 100%, the concept of awal that was created by the scholars, and in fact, to tell you an interesting story, is that algebra was born from the Islamic law of inheritance. So they created these formulas to be able to dissect and break down the heirs and their shares. And algebra helped them with that process. So in the awal side, you have, say, 15 shares, but there's only 14 shares. So there's 15 to go to 14. So there's formulas to readjust so that everybody would receive their proportionate share. So this really is the, idiot's guide to Islamic law of inheritance. This is the framework of how the Sharia articulated the post-death distribution of their assets. Now we're going to go into some details um, about estate planning. So, do you need a will or do you need a trust? And what are the differences between them? So, a will, we say it's a disposition at death. What we mean is that when you prepare your Islamic will, that Islamic will is not enforced until you pass away. A trust is a disposition during both life and death because you establish the trust in your lifetime and it would govern you in your lifetime, during your incapacity, and at death. So the will does not plan for incapacity, the trust does. In the terminology of the will or personal representative or executor, in the trust, it's a successor trustee. And the difference is that with the personal representative, you have to wait until your will is probated and the court enters an order appointing your executor, at which time that executor now has authority to gather up your assets and distribute them according to your wishes as contained in your Islamic will. In the trust, on the other hand, upon death, the successor trustee kicks in instantly. So as long as the trust was properly funded, and we'll talk more about that, there's no court, no probate, no court oversight, no delays to access the accounts. Your successor trustee will have access to all of your accounts immediately. A will has to be proved in probate court. Most jurisdictions require two witnesses, a notary, and you need to prove it before the court probates it. Sometimes if you don't have a notary, it may be an extra layer of proof. I had a situation where we probated a will, and we had two witnesses, but one of the witnesses just disappeared, won't take our call. So we were unable to secure the second witness, which required us to have depositions and have a hearing and have all this extra motion practice so that we can convince the judge to probate the will. So that's where in a trust, it's less likely that it could be set aside because a trust does not require witnesses. There are a few states, there are 2, 3 states that do require witnesses, but the vast majority of states do not. And when it's notarized, there's no court oversight anyways. So your inheritance, your trust, all remains private because it's not a public record, where a will is a public record. You go to the court and you're able to get a copy of that will. We've discussed the estate administration and probate, that there's oversight where in the trust there isn't. Validity is very state specific. You see more contests involving wills because with the will, you have arguments of incapacity, you have arguments, you have to notify all of the heirs in the family tree. So people will need to sign off on certain things and they have to waive certain rights. So that causes more friction and potential for litigation when you only have a will. The big issue also is a lot of our community have property in multiple states. If you live in Texas and you have a home in Florida and you have another property that's in, Georgia, if you die just with a will, you're going to have to open up three probate cases because you have to open a probate case in each state where there's property. But if you had a trust, because the title of that property has been already transferred to the trust, you don't have any issues. You don't have to go to court. You don't have to worry. It's all done. So there's no delay in distribution to the beneficiaries. Is it obligatory to have an Islamic will? We live in a non-Muslim country. In New Jersey, for example, if you pass away, you have a wife, parents, and, four children. Your wife gets 100% of everything. Everybody else is disinherited. They don't receive anything. So that's just New Jersey and many other states that are similar. So if you're a Muslim family that is an extended family, which is who we're all extended family, the power of our economic security and our economic strength is that we're extended families and we're each other's safety net. So imagine you're supporting your parents. Now you pass away, they don't receive anything. That's why you have to either do it in will or trust to protect your family and fulfill your faith. Forget the issue about the money. You're violating the Quranic directive of giving your parents their share. So these things can be very serious from a religious and theological perspective, but they're also very serious in practical terms of how do you manage this estate after your passing. So with a will, you can adjust and make your distribution Sharia compliant. Now, I always, in my practice for 27 years and lecturing so much relating to gender equity in the Sharia, I get this question all the time. So I get a client would come in and would say, "Oh, me and my wife want to prepare a will." And I'll say, "Yeah, sure. Do you want an Islamic will or do you want a secular will?" They say, "Of course we want Islamic, but can you explain to me what's the difference?" And when you explain to the couple who probably been married for 20 years, you know, they own a home together, the wife left her career to raise the children, that on the Islamic will, she will receive 1/8 of the estate, they have a pause. You have folks that are extremely religious and have no issues, they accept the 1/8. But you have equally religious folks, and they ask the question. On its face, we have no issue. The Quran says 1/8. But we feel like under our current circumstances, there's something missing in the equities here. Does the Sharia address these types of circumstances and equities? And I tell them, of course, because the Sharia is a methodology and epistemology that produces knowledge. This usul al-fiqh, this epistemology par excellence of the Muslim civilization, the outcome of that process is fiqh. It's the knowledge. And we know our scholars for the past 14 centuries, unanimously, without exception, have told us that fiqh is probable, uncertain. Fiqh is the science of difference. Fiqh is diverse. Why do we have 4 schools? For many Muslims, they don't realize that up until the 3rd century, there was more than 100 schools of law, like the Maliki school and Hanafi school and Shafi'i school. There was 100. They just consolidated over time and consolidated into these 4 Sunni mainstream schools. And you should also know that the Ja'faris, the Shi'i Muslims, they have also a pretty sophisticated, system in the Ja'fari law, another school. So, because of that, when you apply the methodology to your circumstances, the outcome is going to be different. And there's flexibility in the Sharia. Most people consider the Sharia anachronistic, it's old, it's outdated, it is static, it's inflexible. But all of those descriptions I gave you are the descriptions of Western law, not Islamic law. The Sharia never had this authoritarianism of what is the law. When you go out from the Aqidah part, in the Mu'amalat, the diversity of our scholars is vast. And the scholars, we Muslims tradition celebrates difference. Because think about it. If there was why do we always say that the Islam does not have a church hierarchy? We don't have a pope that says, here's what the church says. We don't have a hierarchy. Because if we had one person that tells you what is the answer, and that's the only correct answer, that's the source of authoritarianism, not accepting diverse opinions. So I provide you with this kind of like intro so that you understand what I'm going to discuss now. Because when I'm asked by my clients, and when I was lecturing and researching and advocating for women's rights, when you dig deeper in the Sharia, you realize there are all kinds of solutions to level the playing field for your wife. So here's the way that you can do it. You can write the property in your wife's name during your life. So you protect her. Everybody knows. You can give a hibah, you can give your wife whatever, you can give your children, your son, your daughter in your lifetime. There's very little restrictions. That's one way. But if you don't have liquidity, if you don't have the ability that you want to give up something and put it in another person's name, you have other ways. Or you have tax reasons for this issue. Because again, for most people, when you leave your home, when you pass away to your children, they get what's called step-up basis. So when you bought the home for 200,000 and when you died it was worth 800,000, there's a $600,000 increase in appreciation. That will subject it to capital gains. But if you give this property to them in your lifetime, you're paying capital gains. If you give your children the house when you pass away, they get step-up basis, which means fair market value at the time of death. So if at the time of death the house was worth 800 and they sold it for 800, they don't pay any capital gains. So there are tax reasons sometimes to plan accordingly. The number 2, 3, and 4, the life estate, the increase the mahr and compensate the wife. These are Sharia compliant solutions for spouses that are available on the Sharia Wiz platform and are available if you hire a lawyer, if you talk to a law firm like my law firm, we do this for our clients. Life estate. So you are free to say, I have this home. When I die, my wife or my husband should have a life estate in the house. The house does not get sold until that person passes away. So you preserve that shelter for the surviving spouse for their lifetime. This Sharia compliant, it's acceptable, no issues. I had a situation a couple of weeks ago. Unfortunately, they haven't called me back to help them, but I got this imam who's a very, very kind and just imam in the community. And he calls me up. He says a brother is likely on his deathbed. He was married before and his wife had passed away, and he has 4 children. 20 years ago, he remarried after his wife passed away. But when he remarried this new wife, they never legally registered the marriage. So because they didn't legally register the marriage, depending on the state that you live in, this was New Jersey, under New Jersey law, they're not married. Their relationship is void. So when he passes away, she gets zero. She's been with him for 20 years, taking care of him, and living in the same house. She gets zero. And his kids get everything. So one of the situations was the proposals, recommendations to stop, to avoid this injustice and travesty that's inconsistent with the Quran. This is what sometimes people think. We are not like the other traditions that focus on the letter of the law. We're a moral system that the underlying objectives and the maqasid matter. So here I proposed we can do a trust and we can put the house in trust, make your wife the successor trustee, and she stays in the house. We can do a life estate. We'll do a will and we'll say she lives in the house until she dies. So the Sharia provides us with all of these tools to make sure an injustice doesn't happen. So that's one of the reasons we use life estate, and you can use this on the Sharia Wiz platform. The third option is increasing mahar. The majority of Muslims, almost every single Muslim I meet, it does not know that the deferred amount of mahar is considered a preferential debt against your estate. So if you gave your wife a $500,000 mahar and you passed away, your assets, the first 500,000's got to pay her mahar. And then the balance, she gets her 1/8 or a quarter if they had no children. So the mahar as a debt against the estate is another tool that Muslim couples can utilize in their lifetime on the Sharia Wiz platform to level the playing field. I've had clients who would say, the marital residence is my mu'akhar. I am modifying my marriage contract to provide the marital residence. So the wife gets the marital residence, gets her 1/8. Everybody is happy, and it's within the strictures of our tradition. The fourth, I'm going to give you, the fourth has two parts. One is the Muslim marriage contract. And this is also something, my dear brothers, Muslim brothers, sometimes miss. The Sharia makes it clear that financial support and responsibilities are gender specific. It is the husband that's required to provide food, shelter, clothing, domestic, medical care, and some schools say a domestic servant to help around the house. That's your responsibility as a Muslim husband. And people try to ignore that responsibility. So what we allow is that the Quran and the Sharia says when somebody does work for you, provide you services, you should compensate him for those services that he rendered. Even though your wife for the past 20 years has been cooking, cleaning, putting up with everything in your family, and raising the kids with all the problems, didn't even continue her career. She did all of this voluntarily, with pleasure, loving, and compliant, take care of the family. But you as a Muslim husband can say, well, you know what, man, she did so much. I should compensate her for all those services in the times that she did. I owe her. That's a debt. So you could acknowledge in your Islamic will or Islamic trust on Sharia Wiz, my wife provided me with a lot of these services. I want to compensate her. So I got to pay her back $100,000 from my assets to cover all of those services. So that's a debt against your estate, She gets the 100,000 plus the 1/8. That's Sharia compliant, past scholar approval. The second, which is also another fascinating story about gender equity in the Sharia. I did this lecture about 2 years ago. I was invited to speak at the New York City Bar Association. It's the oldest bar association in the country. It's on a building on 44th Street between 5th and 6th Avenue in New York City, a historic building. It's awe-inspiring. It is the law in the US. So I get invited to speak in the big room, and they bring a bunch of Western feminists who have a vendetta against Islam. So they speak and attack gender and equality and all this stuff from a Western secular perspective. And I came and I gave the Muslim perspective. And clearly, gender and equity and Muslim female rights was far exceeded everything in Western law until the 1940s, 1950s, and in some states until the 1970s. So yes, between the 1970s and stuff, there's been a mass move towards equality and issues regarding gender, but Muslim women were ahead up until just 30, 40 years ago. And I detail that, and I'm happy to share the lecture if for anybody who's interested, just email me. So why do I bring this up? Because we know that Umar ibn al-Khattab, radiyallahu anhu, Amir al-Mu'mineen, one of the righteous caliphs, he was known and described as what? Al-Faruq, the just. So the just is brought a case for him to rule on. And this is the case. There's a famous dressmaker in Mecca. She made dresses all night. And her husband would take all of the work that she's done and sell it in the souk. In the souk, he was kicking ass, making money. So they've acquired and accumulated substantial assets from the wealth of their business. They had no children. He died. Under the Sharia and the Quranic shares in chapter 4, Surah An-Nisa, wife receives a quarter and the paternal family receives 3/4. So she went to the just, the Faruq. Amir al-Mu'mineen, you know who I am. This is my story. He says, of course I know who you are. Half of that wealth is already yours, and you get a quarter. He flipped the formula. And the Muslim scholars created in the Maliki school a legal theory or a legal claim that's called al-kad was-si'aya. When a wife contributes, shares her money, pools it, works at the business, works in the fields, leaves her career and builds everything and gives her money to her husband, that is a contribution to the acquisition of the marital estate. She has a legal and equitable claim to a portion of that plus her inheritance. This was in 7th century Arabia. This was not the law in the United States until the 1970s. The whole concept of community property and the whole concept of marital assets that are subject to equitable distribution is from the 1970s. For people who don't know this, prior to the 1940s and 50s, when you're married, your identity as a woman in America fused with your husband. You lost your identity. Everything you acquire, your wages, your assets, are your husband's. There is no independent financial capacity. Islam from 7th century created the protection of women. They have independent financial capacity, not fused. So this kadwa si'aya, you can do it on Sharia Wiz on the platform to protect your spouse and to level the playing field. But everything I just told you are options. They're not mandatory, they're not required. They depend on the specific circumstances of your life and your case and your relationship. But they are available. Debts and bequests, حقوق Allah. Many people, do you understand the sophistication and the genius of the Sharia? That حقوق Allah versus حقوق العباد, that Allah and the Sharia put preference that حقوق العباد have to be paid first before you pay حقوق Allah. Get the level of justice, fairness, and equity. So if you have حقوق Allah, you are able on the Sharia Wiz platform to accept, here's what I owe, here's the things that I need. You want Hajj Badal, you want somebody to do Hajj for you if you're not able to. Do you have any zakat, any kafarat, any nizars? All of this can be included in your Sharia Wiz Islamic will or Islamic trust. Now the big piece. And this piece is so important to explain because sometimes when you listen to explanations of Islamic law, you're just being told like a simple thing, like, oh, guess what? You can give up to 1/3 of your assets to a sadaqah jariyah or to poor relatives. And you stop there. But nobody digs deeper to understand the hikmah and the divine vision of why you leave a sadaqah jariyah. Not only is it because Allah is going to reward you, you're actually building the Muslim civil society. You're actually building institutional depth. You're actually sustaining Muslim institutions and civil society. So the whole purpose of this 1/3 is to go, I want my sadaqah jariyah to continue. Now, how do I do that? I can put piece of it in waqf. I can give it to Helping Hands, to other organizations, to my mosque. And that money is going to continue to give and it's going to sustain the Muslim civil society. And that's what made Islam throughout history powerful. If you realize that in Turkey, up until before the end of the Ottoman Empire, almost 60-70% of arable land were owned in waqfs. Did you know that almost majority of the city of Jerusalem is owned by waqfs? In Damascus, in Cairo, in many of the Muslim countries in Africa and in South Asia, the waqf was the safety net, the independence of the civil society from the ruling caliphate, from the political. So this issue of the 1/3 becomes about building our community. So that's why when I have my clients or when they come on the website, we encourage you to support and sustain our institutions. The majority of the money that Harvard, Yale, and all these endowments receive is from legacy giving from their alum. We started this 1,400 years ago, and they have surpassed us, and we're still behind. Very few Muslim organizations in the United States have sufficient endowments. I will not exaggerate that the vast majority, if they do not raise money every single day, they are from one donation to bankruptcy. We are constantly trying to raise money so that we can do the good because we're not doing our waqfs, we're not institution building, and we're not sustaining them. So please keep this in mind when you prepare your estate plan. So the elements of the foundational estate plan is that we want to cover lifetime and a death, like I've explained. Estate planning is a process, it's not an event. It's a work in progress. I had a client meet with me a couple of days ago, and he has a lot of assets and he's traveling. And he says, "Oh, I'm not sure what I'm going to do with my assets." So I asked him, "What will you do? What do you want to happen if you die tomorrow?" We prepare your Islamic will based on what you want to happen if you die tomorrow. Now, 6 years later, and you're still living, and there are changes in your life, we have to update. We have to make differences. We have to do modifications. Things change. So you have to cover what's going to happen. Your worst case scenario is tomorrow. And also in your lifetime, incapacity, living will, all of these issues should be taken into account now. So lifetime planning, powers of attorney, medical directives, living trusts, funding documents. This is what you're doing in your lifetime. At death, you will have revocable living trust and pour over wills or regular wills. And again, as you can look at the chart, revocable wills cover you both in lifetime and in death, which wills do not. Next, what I want to talk about, one thing to fast, the concept of the waqf and the concept of the trust. Somebody asked me last time, "Oh, how was a trust Sharia compliant?" Because Islamic law created the concept of the trust. In the world, there's two legal systems. There's a common law system, England, and then there's a civil law system, France. In the French civil code system, Germany, Switzerland, all of Western Europe, there is no concept of waqf in their law. The only place a trust is found is in the common law. Prominent professor, a law school named John Makdisi, an Arab Christian on top of it, not even Muslim. He traced the origin of the trust and discovered that prior to 1000 AD, the trust did not exist in the common law. It entered in the 1000 AD. And he saw the link was when the Normandy expansion came to Sicily, and you had Roger the First and the Second. They had an unbelievable, sophisticated administrative system that Muslims left. They didn't reinvent the wheel. They learned what they learned from the Muslims, and they took it to the mainland. So that keeps you in mind. Trusts are Sharia compliant because we created them in our tradition. Now, the last thing I'm going to discuss, and I think me and Brother Hammayun are planning to create a specific webinar on special needs trust. So this is kind of a teaser just to have you think. I have a client today who he's probably worth $7-8 million, and he has two children. One of them is disabled. He has an autistic child that's not going to be able to be self-sufficient or self-supporting. And he's going to need medical care. So if my clients pass away and one son gets a 1.5 million, and then the other autistic son's going to get 1.5 million, that 1.5 million is going to medical care. It's going to go, it has to be spent to doctors, hospitals, therapists, because now the child will not qualify for public benefits or Medicaid. So what we do in this circumstance, I'm creating a revocable living trust for the client, but I'm also creating a special need trust for his son. So when he dies, that 1.5 million does not go to the child directly. It goes to the child's supplemental special needs trust, not his assets. Therefore, he qualifies on all the need-based public benefits from Medicaid to Section 8 to what have you. And now we have $1.5 million in that trust to supplement and make sure that the lifestyle of our disabled child is amazing. He needs a house, we'll pay the rent. He needs special schooling, we pay for the school. So we're able to utilize all of this extra money to improve his lifestyle as opposed to spending it on medical care. So these special needs trusts are very important. We have a lot of members in our community, just like everybody else. We have disability and disabled kids. And I think we'll do a lecture on this. So the people who need it are under these age groups, even sometimes elderly need it, um, because people are disabled and they're old. Um, the special needs, it covers you for purposes of education. It covers you for how all the financial and healthcare decisions are going to be made, about employment, about quality of care, quality of life. All these 5 categories are covered in the special needs trust. Uh, all of us have to ask that question. What will happen if I'm not here? Am I going to burden my other son with our disabled child? How do we help them? I mean, I'm a mother and father and I'm taking care of them, but my son's going to have a full-time job and he's going to have his kids. How are we going to work this out? I got to make it easier for my other children to help their sibling. I have a case right now. The child has a mental illness. He's schizophrenic. You can't give him $3 million. You got to create a special need trust for him and make it easy so the siblings can manage their brother. So as you can see, these are the reasons we need it. We need caregiver, like living arrangements. Where is he going to live? Education, employment, government benefits, managing the assets that he's going to receive in inheritance. All of this is covered in the special need trust. And I've explained this, that you will qualify for all of this SSI and Medicaid because the child doesn't have any money. There's 3 types of special need trust. A first party special need trust is complicated because a first party would mean, God forbid, I got into a car accident. I'm a healthy guy, got in a car accident. Now I'm crippled. And I got a $10 million settlement. Well, I don't want that $10 million to go all to Medicaid. I want to live. So I, myself, can create a first-party special needs trust. And the government can't touch my money until I die. So I will qualify for public benefits, but Medicaid and the government have a lien on my trust. So when I kick the bucket, any money in there, the government takes. Third-party special need trust. That's the most popular one. That would be, I'm a parent, I'm doing it for my son or daughter. I'm a brother, I'm doing it for my cousin. Anybody can do a third-party special need trust, and any money left in that trust will go to whoever you decided to be the beneficiaries after the disabled child passes away. The pooled trust is more complex because it really is it's similar to the first party, but you don't have to manage it. You have an entire trust administrator that knows all of the complexities of the laws relating to Medicaid liens and so forth. So I think this gives you a really good introduction to the Islamic law of inheritance, to American-based estate planning, how to protect your family, preserve your wealth, and fulfill your faith. And we gave you a little nugget about special need trust, something that we really need to raise awareness in our community. And I'm happy to take all of your questions. Thank you.
Jazakallah khair, Brother Abid. Any folks, we are quite a bit, 24 of us. Anybody has any questions, please unmute yourself and ask before we end. We'll take as many questions as long as you want to wait. But just to say that I've posted the links on it, recordings of all our webinars and this one will be posted to HHRD YouTube channel, which is also available. The link is available on our website under HHRD/plan giving. No questions. Looks like this time along it was pretty good. Last
No, I
month we
think
had a lot of
it was
questions.
very good. Thank you very much. I appreciate
Oh,
it.
not a problem. Thank you, brother. I appreciate that.
Alhamdulillah.
Uh, it was really good. Thank you. Quick question in terms of, so if you only have daughters and you have a wife, then do you have to use any of these special trust, or is it just like a
Oh,
regular trust?
no, no. The special needs trust is for disabled children. If your
Okay.
children are not disabled, that doesn't apply to you. I get this question all the time. I only have daughters. I want to leave everything for them. My brother's in India, my brother's in Egypt, my brother's in Africa. They have no contact with my kids. What do I do? Because under the Sharia, if you pass away and you only have daughters, let's say you pass away, you only have daughters and you have brothers. Your daughters, if it's one daughter, she gets a half and your brothers get a half. If it is more than two daughters, it's two and above, your daughters will get 2/3 and your brother gets 1/3. So your siblings will inherit if there's anything left in the estate. Now, the reason the Sharia did that is because daughters are also considered obligatory heirs, Quranic heirs. Because the Quran wants to say, listen, daughters are inheriting, period. So they'll inherit half or they'll inherit 2/3 amongst each other. So that was a protection. So if you have a son, your brother does not inherit. So the son blocks siblings. Strictly speaking, that's the Sharia. There is some discussion in like Morocco that based on verse in Surah An-Nisa, verse 274, it discusses does a brother inherit from his sister? Sister passes away, do you, as her brother, inherit from her? And the Quran says, if she has children, if she has a child, you do not inherit. And the word child in the Quran that was used was gender neutral, which meant whether it's a boy or a girl. So some people say, based on that, you could block your siblings. That's not the mainstream position. That's not the acceptable position to most people, but there are people who do that. Another version is the Ja'fari law. Ja'fari law, daughters block siblings. So that's the Shi'i law. They block siblings, so the daughters would get everything. So these are the options you have. If you're very, very strict on Sharia compliance, another option would be creating a trust that continues after you pass away. So you put your assets into the trust, you pass away, you can exclusively say the income, al-manfa'a, the profit from the trust goes exclusively just to my daughters. That's Sharia compliant, no issues, because it's not considered inheritance. But when the trust terminates, any assets left in the trust, the principal has to be distributed according to the inheritance rules. So I gave you kind of like the framework of a bunch of options for you to consider.
Jazakallah, brother. I have a question I posted. If somebody challenges, because of Sharia, there's no law in this court, in this country, But if they give the disproportionate, let's example, wife get only 1/8. Legally, she can get more in this country, right?
Yes.
So how the overwritten the law will throw out of that?
So here's how that works. First, on Sharia Wiz, with each Islamic will and each Islamic trust, you are also receiving an elective share waiver or a community property agreement. What that means is if you and your wife are going to say, we waive our rights to Texas inheritance law in favor of whatever we receive in our Islamic will. Those waivers, generally, if it was not entered into under coercion, pressure, or what have you, are going to be enforceable, and your
Okay.
will be enforced. Now, if you don't have that signed, the only way that it'll be contested, wife has to contest and go to court. And when you go to court, you don't get 100%. You're only allowed the elective share. And the elective share is up to 1/3 of the estate. So that's why the Sharia wills are legally valid and Sharia compliant because we take into account all of these factors.
But it's you said only wife will contest, but husband also can contest because he
Well,
won't be
husband is
getting.
going to get a quarter or a half.
Yeah,
So
that means anybody can contest, right?
any beneficiary,
Yeah, any beneficiary. Let's say wife is gone first, then
yes. So what,
he's not getting everything. So
he's not. He's not getting everything from his wife's assets.
correct.
So he will receive, if they had children, a quarter. If they had no children, a half. So under state law, he was going to get maybe a third. So it's not that far off for the husband.
Yeah. So that meaning the pre-agreement, that's what you're saying, that will waive the waive the provision to not to contest. That's what I think you are.
Well, it's not about not to contest. It's more like I'm waiving my right to 1/3 of my husband's estate in exchange for 1/8.
What happened if she changed her mind tomorrow saying that is
Well, once you waive it, you can't change your mind. And if
yeah,
she
but they
does,
said that time there's a forced agreement.
well, listen, if she's going to change it, she's going to get 1/3, you know. In the end, if the court finds the waiver valid, there's no change.
Okay.
But if you're right now, you're going to call up your wife, say, I'm going to divorce you if you don't sign this.
Yeah.
Well, that's not going to be valid. That means she was coerced and pressured to sign the waiver. So it's very fact specific.
Okay. Thank you, sir.
You're welcome. Any
I'm
other
going
questions?
to, yes,
Yes,
Jazakallah khair. Brother, I have a question. Jazakallah khair for going into the detail for this. I have a question. We moved from another state. We moved from California, and we have an Islamic will and a living trust already established, but it was established in California. So when we move to Texas, do we have to make any changes to the trust at all, or does it
Well,
still apply here?
technically, if it was valid when it was established in California, it will continue to be valid when you move to Texas. Sometimes, and like I explained to you, estate planning is not an event, it's a process, it's a work and document. Sometimes it may be a good idea to update it if you're going to really totally relocate into Texas. You can update your will and continue your trust um, while you're in Texas and make it apply Texas law because California is a community property state, so things are a little bit different than in Texas. You can go to a lawyer to update it and restate it. If you don't have a complex estate, if it's, you own a home and a couple of little things, you can do it on Sharia Wiz. And I'm not sure what type of living trust you have because the family waqf structure we have is very unique, where you both put your assets together and they are distributed only after both of you die.
Okay, yeah, Jazakallah khair. Yeah, the way we have it is we actually have our home as well as some of the other assets in the name of the trust itself, rather than us individually owning them. So we made sure that everything is under the trust name. But again, and the trust was valid when we moved here. But yeah, I just wanted to confirm that we won't really have to
Again, it's
make
still
any
going to be
changes.
valid, but maybe advisable to update to make sure that it covers any few changes in your life.
Okay, sounds good. Great. Thank you. Jazakallah khair.
Brother Abid, there's another question is that you mentioned earlier that if the trust get terminated, what do you mean by
Very simple.
terminated?
When you create a live-in revocable trust, that live-in revocable trust is going to cover you when you're living. You are the grantor, you're the beneficiary, you're the trustee. It's your live-in revocable trust. But when you die, what happens to the assets that are in the trust? Because now the trust is going to terminate and the trust property is going to be distributed to your Islamic heirs. So that's what it means to terminate. Now, the fact that you passed away, most people, it terminates the trust. But you can decide you don't want the trust to terminate when I die. I want it to continue. I want it to continue for another 50 years. I want it to continue for another 10 years. I want it to continue until my wife passes away. So that means the trust doesn't terminate, continues until the happening of that event. Then it terminates. When it terminates, distribution of the trust property's got to go to the heirs, to the beneficiaries.
We had a hand raised. I
Here's
don't
somebody
see
asking
the
about
name.
about Medicaid.
Medicare trust also.
Yeah.
Yeah.
Those I tend not to do. I've had one of them that I was working on, but the Medicaid trusts are very unique for limited circumstances. So if you own a home, you and your wife, it's paid off, you really don't have any other assets. You just have the home. So I don't want Medicaid to take my home. I don't want if I get disabled, now I'm going to go to the hospital. They're going to sell my house. They're going to have a lien on my house. And I've been wanting to leave this to my children. So if you strategize it and play it correctly and you create a Medicare trust, it allows you and your wife to live in the house, but you no longer own it. So because you no longer own it, you qualify for Medicaid. But Medicaid trusts have what's called a 5-year clawback. So if you establish the trust today and 2 years you're disabled, the government goes back 5 years and you're out of luck. So you have to stay not Medicaid needed for 5 years from the time you establish it.
Brother Shonan.
Brother Abed, Jazakallah khair for presenting. I'm Shona, and I actually work with Humayun at Helping Hand. I don't work with him directly. I'm in a different department. I spearhead upstate New York's fundraising and regional outreach efforts.
Oh, cool.
Thank you. Appreciate it. And so yeah, my question is, I don't know if it's related, but I overheard that you did prenups, and right now I'm still a bachelor, so in the process of looking for someone. So I guess my question is it advised to do a prenup before I get married, or is that something to bring up? I always saw it as something that rich people do, but I don't know.
No.
What do you suggest to young couples? Yeah.
Everybody thinks that prenups are for rich people. No, they're not. Number one, for Muslims, I'll tell you, I've been doing prenups in my private practice for 27 years. In the past 3-4 years, they've gone up 300, 400%. Everybody and their mother is doing a prenup, and for a variety of good reasons. The Sharia compliant prenup that I prepare in my office, or you can go to shariawiz.com and get your Sharia compliant prenup online at a fraction of the price, of course. It basically creates contractually Islamic family law. So in the prenup, it includes 3 documents, the package that makes a prenup Sharia compliant. You have the first, the prenup. After you sign the prenup, then you have the marriage contract, the nikah contract. So that's prepared on Sharia Wiz or in my practice. After you're married and you sign it, now you got to do your Islamic will. Because for it to be Sharia compliant, you in the prenup are responsible for food, shelter, and clothing and medical care. That's your responsibility as a husband. She's responsible to provide you companionship. You're going to put in whatever the mahar is, advanced, deferred, what have you. And also, Sharia Wiz gives you the option of something called nafaqat al-mita'. This is a concept created by Muslim scholars, which said, you know what, when you get divorced, sometimes maybe a good idea to compensate your wife for past services she's done for you. So you can say, if I'm married from 1 year to 5, it'll be 50,000. I'm married from 5 years to 10, it'll be this much. So the Sharia compliant structure covers in the event of divorce or in the event of death. So in the event of death, you get your 1/8 or you get your quarter or whatever the inheritance is. So that's why the package is 3 interrelated documents. This can be done at a law firm if you wish, or it could be done on shariawiz.com. And the reason people are doing it to avoid court litigation. Divorce lawyers charge, depends. If you go to a good lawyer, minimum $500 an hour, up to $800-900 an hour. Divorces can cost you 15-20. They can cost you $1 million, depending on how much assets you have. It's a nightmare. Divorce is a nightmare. There's a tradition in hadith that says that when people divorce, I mean, I think it's a solitary tradition. It may not be authentic and reliable, but everybody says it, that the divine throne shakes when people divorce because it's destruction of the family. So if you have all your financial circumstances sorted out in your prenup, you avoid all of that uncertainty. So it's important. So people who are young professionals, they may have some money they want to protect, or they're just worried about the future. Also, more parents are requiring their children to get a prenup. Why? Because your father worked 8 days a week and saved all his money and got this house that's worth $1.5 million. And he says, I am God, I am not giving that to this woman that you're going to marry from the other family. I want that protected for my kids. So because we have assets as parents, we're like, we don't want this to go to the wrong person. Get a prenup so we can protect our assets. So that's another reason a lot of people, do prenups.
Okay, thank you.
Jazakallah khair, Brother Abid, and for everybody to join. For respect of time, Brother Abid has given us almost an hour and 20 minutes. We would end the program, and inshallah, like Brother Abid said, we are working on other programs, and the goal is to bring you all a webinar every month to educate ourselves on our legacy creation, establishing our legacy in one way or the other.
Exactly.
So I just want to thank Brother Abid for helping us. He's just a phone call away to me, at least. Always his staff is, and he's been very, very, very supportive for the last 3 years. I just want to make an announcement that Brother Abid's organization, Sharia Viz and Helping Hand, collaborated, and whoever wants to make their will through the platform, do-it-yourself platform, shariaviz.com, you can make your will for free. You just have to reach out to me. I'll give you a code. We still have quite a bit of codes left. It was for first 50 clients who does it. So you can make your will yourself for free of cost. As far as it goes to estate planning, because that's involved a little bit more research, more planning. So that's not free, but you reach out to Brother Abid. He's promised he will consider you're coming from HHRD and he'll make it worthwhile for you, inshallah, and save even more to make your legacy, inshallah.
Inshallah.
So Jazakallah khair, Brother Abid, Jazakallah khair, Brother
You.
Hafiz Arbaz, who did the recitation, and all of the 25 people, brothers and sisters who joined us. As we part, I humbly remind myself and all of us, our time in this world is very limited. But what we leave behind can continue to benefit us and our organizations who are doing such good work 24/7, round the clock, around the globe. Even a small step taken with sincerity can become a source of sadqa jariyah for the years to come. I invite you all to explore hhrd.org endowment and hhrd.org Kindar Hospital. These are the two very important steps, initiatives we have taken to sustain our organization for just what Brother Abid talked about earlier. We are as far as one donation to go bankrupt. It could be that way. We don't know what tomorrow can bring us. So requesting, we created this endowment fund 3 years ago. It will take us some time to come up to that level where we can sustain our self without taking any donation out from the donations we received. So visit us, endowment, donate towards us. And Kindar Hospital is one of a kind. We are building and started operations in Karachi, Pakistan. It's a $60 million project. First 10 million, 7 million has been built. Started operation as of January. Inshallah, it will keep on going. Visit us. If you are from Karachi, Pakistan, you visit there. Reach out to us. We'll set up a visit to go see the hospital in running. Makes a difference. So Jazakallah khair for once again. May Allah subhanahu wa ta'ala grant us the patience, grant us the energy to keep doing what we are doing. May Allah subhanahu wa ta'ala accept from all of us and make what we leave behind a light for us in our akhirah.
Yeah,
Ameen.
and me.
Ameen.